Jamie Raskin doesn't just criticize the DOJ, he lays out a trail of decisions that undermine the law itself, from halting corruption prosecutions to dismantling watchdog units. Each action sends a signal. Accountability now has limits. And the question hangs over every American: who really faces justice in this system?
Mr. Raskin.
Thank you very much, Mr. Chairman. The Department of Justice announced that it would demote the Foreign Corrupt Practices Act and not bring prosecutions there. It sacked 17 inspectors general when it started, people who saved us a combined $91 billion last year in ferreting out waste, fraud, abuse, and corruption in the government. It pulled the plug on the corruption prosecution of Mayor Adams in New York after Mayor Adams agreed to engage in a political alliance with Donald Trump, which then prompted the resignation ultimately of 6 or 7 attorneys, including the U.S. Attorney for the Southern District, Danielle Sassoon, who was a conservative Federalist Society lawyer and a Republican. Her number 2 also quit, saying that you'd have to be a fool or a coward to give in to this kind of pressure. Then they decimated the Public Integrity Unit. They dismantled the Kleptocracy Unit in Department of Justice. They shut down other units focused on stopping foreign interference in American politics. Mr. Fox, why is prosecuting white-collar crime with the, specific enumerated offenses with the definite material elements in the crime, why is prosecuting white-collar crime important?
Yeah, so I looked, it seems like there's about maybe 7% or give or take of crimes that DOJ prosecutes. It seems like that will fall under the white-collar category. I think, there's a lot of the work that the federal government prosecutes are things that far exceed the doctrine of enumerated powers, or things that the federal government has absolutely zero business getting involved in. I think white-collar crime is one that arguably can fall under the ambit of the federal government, and it's something that is important to, discourage political corruption, make sure that people are, being prosecuted because the Department of Justice has evidence that they committed a crime, and they're not being prosecuted because of, what their political views are, or that they're not being let off because of what their political views are. People don't trust a system that targets people or that ignores people based upon the views they espouse or the people they support.
So do you think that undermines public trust in the justice system?
Oh, dramatically.
It sends out the message that we have this 2-track system, one for people who engage in kind of the run-of-the-mill state law crimes like assault or theft or robbery, and then one for white-collar criminals in the government or in corporations or in politics who are able to get away with it if they know the president or they know the right person.
Yeah, I think that's right. And it also goes back to the question Ranking Member McBath asked, which is, about are they going to target people who they know will fight back versus won't or won't have the resources to? So I think, that's all very related there.
Yeah. Have you studied the whole question of whether there is systematic inclusion of a mens rea requirement, so we're not putting people in jail for most regulatory offenses?
Yeah, so a lot of regulatory offenses, and frankly also a lot of statutory crimes, don't include a mens rea. The theft charge that I talked about before in the Moore and Mansell case, if I were to take Mr. Canaparo's water bottle and give it to Professor Turley, we're on federal property, technically I could be charged. That's preposterous. No reasonable person would ever think that's theft, but without an actual explanation as to what theft is that I actually intended to, take his wallet and bring it home with me, people would, they would absolutely, fall victim to these types of prosecutions, which dramatically undermines trust in the system.
Yeah, I understand that the chairman and I think Ms. McBath have this Count the Crimes Act, which suggests that we don't even know how many crimes we have. There's been such a radical proliferation of offenses throughout the federal code. But do you think it would be advisable for us, once we've counted the crimes, to propose a Cut the Crimes Act, where we get rid of a lot of the offenses that transform malum prohibitum regulatory crimes into real criminal offenses that most people would think should apply only to malum in se?
Yes, certainly. I know the chairman also has the Mens Rea Reform Act. I think those two things in tandem, if you set a default mens rea, that way, we're not sweeping people into the criminal justice system over things they didn't know would be crimes. And then also, I'm not sure it's actually possible to count all the crimes, but assuming we can do that, then we're able to sort of come to a consensus as to what doesn't belong. But I would also say, if we're not able to do that, there's other changes we could do. Like, I have an idea that we could just inform jurors that they have the power to acquit against the evidence when justice requires. So in a case where the Department of Justice brings a charge, like the case I discussed before, where any rational person would think it's absurd, the jury can be like, you know what, we don't agree with the defense theory, this is nonsense, we're going to acquit. And that's a power they still have.
And I yield back to you, Mr. Chairman. I don't want to commit a criminal infraction here by going over my time.
It's too late.
Too late.
Yeah.
What Jamie Raskin does in this hearing is methodical, precise, and devastating. He doesn't rely on spectacle. He relies on facts, records, and patterns. And through them, he tells a story that any American should understand. He begins with the Foreign Corrupt Practices Act, which exists to stop bribery and political corruption tied to foreign entities. When the DOJ demotes enforcement of this law, it's not a simple reprioritization. It is a signal to corporations, foreign actors, and domestic players alike that political convenience can outweigh accountability. The principle that the United States enforces anti-corruption consistently is weakened. Then, Raskin highlights the removal of 17 inspectors general, officials who serve as internal watchdogs across federal agencies. These are the people who prevent billions of taxpayer dollars from being wasted, who expose fraud, abuse, and corruption inside the government. Removing them doesn't just reduce efficiency, it removes the backbone of accountability in federal operations. He then traces the consequences further. The DOJ dropped a corruption case against New York City's mayor after a political alignment with Donald Trump. This wasn't just an internal policy decision. It triggered mass resignations, including seasoned Republican career attorneys who said the pressure was impossible to ethically withstand. When experienced lawyers resign rather than comply, it signals a profound institutional breakdown. Raskin continues by connecting these actions to broader systemic issues. Units that focused on public integrity, foreign interference, and kleptocracy were dismantled. Each of these units served a critical role in protecting American democracy and public trust. Their removal leaves a gap that cannot easily be filled and tells the public that some wrongdoing may be tolerated if politically convenient. The discussion then moves to white-collar crime, a category often misunderstood. These offenses are not street crimes, they are crimes that shape markets, influence politics, and determine whether people in power are held to the same standards as everyone else. When these prosecutions are delayed, ignored, or politically manipulated, the justice system sends a dangerous message: one set of rules for ordinary people, another for the powerful. Raskin also explains why the law needs a clear mens rea, the intent element. Without it, ordinary people can be criminalized for actions they didn't even know were crimes. When this interacts with selective enforcement, the system stops being predictable and fair. Justice becomes discretionary, dependent on political influence rather than facts or law. Taken together, these actions by the DOJ do more than reduce prosecutions or cut budgets. They erode public trust, weaken the principle of equal accountability, and create the perception of a two-tiered justice system. Raskin isn't theorizing, he's showing that each decision compounds, leaving the law selective and conditional. The implications reach every American, every voter, and every citizen who relies on an impartial system. The final takeaway is sobering. Accountability cannot be a matter of political convenience. When oversight is weakened, prosecutorial decisions are politically motivated, and enforcement is selective, the foundation of democracy itself is threatened. Raskin's line of questioning forces the public to confront a difficult reality. When justice is no longer blind, it serves only those in power. Should accountability be selective? When enforcement of law depends on political connections, what does that mean for democracy? Share your perspective. How can Americans demand a system that treats everyone equally?